All righty. My name is James Greenwood. With me, I have Benjamin Young. Today, we're talking again on our Protecting Your Legacy One Lunch Break at a Time series. Um, and we're talking about these emergency estate planning incidents, right?
Mhm.
So what can be done at the last minute? We're trying to figure out what's going on. All of a sudden we realize, hey, somebody needs a will, they don't have one, or maybe they need some powers of attorney in place. Maybe there's some sort of designation that needs to be made for who's supposed to be taking care of the kids. We have a lot of these opportunities at the last minute. So we're going to talk through those, and I think the common ones: wills, powers of attorney, guardianship designations. Top three, that I've seen very consistently on this, and we'll kind of work through those. Talk about when is it maybe a little too late to have those conversations, very briefly, and then we're going to address how to tackle getting a hold of an attorney for those emergent planning needs. So, Ben, before we get too into the weeds here, what have you seen? I mean, I know that I've done some work, you've done some
Yep.
work. What
And
have
I
you?
know just about any estate planning attorney has done hospital bedside wills and things like that. So I mean, the biggest concern, I think, just like you mentioned there, is capacity. That's the biggest question when we're dealing with all of these emergency measures. And this is where the law talks about testamentary capacity, not contractual capacity, which is what most people kind of think of as, do two people understand what it is they're signing up for? Testamentary capacity is a different threshold. Sometimes I look at it as potentially a lower threshold if that's the case. But again, what it does is it leaves us a little bit of flexibility that if there is some last minute or last second planning when it comes to this stuff, there is still the chance to be able to get it done.
know? And one of the things that I always like to emphasize is that, if there's a current estate plan in place, oftentimes the right answer is to leave it alone. Um, One of the frequent things that we see are somebody's worried that, oh, my executor died and I want to update the executor, and that's fine. We see that all the time. Sometimes people are worried that maybe they excluded a child and now they want to include them. And that's also okay. I mean, we've seen all these things, but sometimes if there's not really a big change, if it's just, oh, I just want to get this done, the answer might be, um, let's save the stress and the worry. Um, but other times, if it's going to help provide some comfort and some peace of mind, we'll go out, we'll do it. It'll look pretty much identical. We don't like wasting people's money, but at the same time, if it's worth that peace of mind to that person at that point, we're always happy to take a look at that and do it. So let's get down to brass tacks here, and let's start with the wills and those end of life planning opportunities where a will is the right answer. Ben, what have you seen with those? And you mentioned hospital deathbed wills. People don't like calling them deathbed wills. I don't
Mhm.
think, and there are a million and one euphemisms for these things, but let's call it like it is, right? And
Right.
that's always been my philosophy. It's a deathbed will. Somebody's dying. We're showing up because they called us and they said, "Hey, I want to do a will."
hmm
Um,
So a lot of times where the focus becomes is what is the real goal at the end of the day. If things are so again, we've talked about this in previous episodes before is hey, there's already an Illinois statute in there that takes care of everything and says where everything goes. Does that meet with your needs? And if it doesn't, then yeah, the will may be the way to overcome that. So the big difference there is when we've talked about wills versus trusts. Wills are much simpler, much easier for people to understand. So if they're in a state of maybe their capacity is being questioned, it's a lot simpler if they want to make sure they know who's getting what and who's in charge, that a will can at least take care of those things quickly and be able to be executed when somebody doesn't have a lot of time to do it. So it's still, and again, I know I'll keep coming back to this though too, is what is testamentary capacity? And maybe we should cover that a little bit here first. But what testamentary capacity is one, they have to understand what it is they're doing. They say understanding the act of creating a will, right? They have to understand what it is and what its legal effect is. Two is they have to know the nature and extent of their property. So what that's saying is, what do they own? Where do they have accounts? If all of a sudden they think, well, all I own is a house, but in fact they own 800 acres in some other state, they don't know the nature and extent of their bounty. It doesn't mean they have to know account numbers and balances for the day, but just have a general idea of what it is they own. Third is this is always the fun one when I talk to clients, is identifying the natural objects of their bounty, which is just saying who are their family members and who are the ones that are kind of expecting to be the beneficiaries. So when Illinois law fills in and says who gets what, you need to have a basic idea of who those people are and what they're supposed to receive. It doesn't mean they have to receive it, you just have to understand that. And then the fourth thing is just you understand the disposition you're making. So, in other words, if you come up with a really complicated way of distributing things, it's going to be a lot easier to challenge than maybe they didn't know what they were doing. So, after you're able to establish that, now you can move on to, hey, let's get a simple document in place that gets things to where they're supposed to go and who's going to be in charge of making sure that happens.
Yeah, and yeah, I think the thing that I always tell people is it's the people, the stuff, and who gets it, right? That's it. And if you can't articulate all three of those things, then you can't make a will. The thing that I see with our younger folks when we go in and do this, and we're talking folks who still have minor children, that is very important to them, is the designation of who's going to care for the kids after they pass. And either because um, uh, the other spouse or other parent is already deceased, or because they're out of the picture, they can't or won't take care of the kids. Maybe we don't know who that other parent is. And so when we're thinking through those things, those designations can become exceptionally important, especially for our non-traditional families where an adoption hasn't yet occurred. Um, and most of the time you'll have people who have some sort of agreement among the family members of regarding who's supposed to get what, and that's fine, right? um so when we have those conditions, those designations are incredibly important. Other things that we see is maybe they just want somebody else, somebody specific to be in charge. They may not even want to change the distribution plan from whatever's in the state that they're in. So if you've got kids and your spouse is already predeceased, everything's supposed to go to your kids. Um, and all the kids are living, and we look at it and we said, okay, well, all the kids are living. This is the same as what would happen if you were to pass without a will. What are you looking to achieve here? And the answer might be, I want this specific kid to be in charge. Or maybe the answer is, I don't want any of them to be in charge. I don't want them fighting.
And
And
a
I know
lot of times, I think when we do wills, it does lean that direction. I think you've probably seen that, James, is it's not necessarily there's one kid they want to be in charge, but often rather than not, there's one kid they do not want to be in charge. And yeah, the will is definitely going to accomplish that.
absolutely. So emergent estate planning, usually with those, when we get those phone calls, I know that, I get an email every time we get a phone call, and I'm sure that even if it's after hours, and I'm sure that other attorneys work they have some sort of method there, right? But we usually get those phone calls. Either my phone might ring depending on the time of day, or I'll get an email. And usually there's been a number of times where at 6 or 7 at night, I've gotten a phone call and I'm at the hospital by 9 o'clock at night and we're talking, right? And it's not a great time, but it's important to make sure that our community is receiving those services. So it's something that we always keep in mind. Other places where we see this type of thing a lot, powers of attorney. Who's going to make those end of life decisions? Who's going to handle the financial pieces? Most of the time, with these kind of emergent estate planning pieces, we see this a lot with like upcoming surgery or maybe a surprise surgery or something like that, where somebody knows they're going to be down for the count for a while. They want to name somebody to handle their financial affairs or make their medical decisions for them. That's a little more clear than maybe what the statute might provide, or might be a different person than the statute might provide. And so we get those phone calls all the time. They're pretty straightforward, and we're always happy to have those conversations and evaluate what the opportunities are there. And when we see those powers of attorney going into effect shortly before a disability, it's always something that we're careful with, and we have to think through what are the implications of this. And powers of attorney are a little different. The competency level required for a power of attorney is much higher than a will, typically. So when we have those, we're always concerned about, hey, does this person really understand what's actually going to happen as a result of this designation? And are they able to understand the effects downrange about this power of attorney being in place? Oftentimes, the strategy that we use is a limited duration power of attorney. That's been something that I've done a few times, where I say basically, hey, this power of attorney is effective from the time that my client goes into surgery until the time that they wake back up and are deemed competent by their provider. And the instant that is done, the power of attorney ceases to exist. And we say, hey, look, we'll be happy to rework this thing later on, provided you survive. But we're going to limit that scope so that way it's pretty narrow and pretty defined. There have been a number of times I've refused to do powers of attorney for property, just flat out refused, because people are not able to fully understand everything and the implications of a power of attorney for property. We've discussed this in prior episodes, is that whoever takes over has all of the powers listed in that power of attorney for property, and those powers can be incredibly broad, including the ability to sell property, to move assets, to transfer, potentially to gift assets, depending on the state law and what's in that power of attorney. And so there's this broad set of powers that maybe we're giving, and we're looking at it and I'm saying, I think that we're probably not going to go ahead and execute this power of attorney for property. We'll just do the will, because we don't want somebody interfering with what's in that will. So we've seen that a few times, and unfortunately, we've had to decline on the power of attorney for property, but a few times. But for the most part, we've been pretty successful at identifying those places where we needed to. Ben, I'd love to get your thoughts on trust planning at time of death. I haven't loved that at all, but I mean,
so it's kind of back to that same question of, do they really understand what it is that they're doing, right? There's always that saying of, you can get things done fast, cheap, and done well, but you only get to pick two of those things, right? And a lot of times the big issue there is trusts take a lot more legwork. They take a lot more intricacy in getting the document put together. And when you're rushing it at a last minute like that, what you're doing is you're asking for a lot more mistakes to potentially be made. And if it's a deathbed situation, You don't have time after the fact to go back and change that if there's something that maybe didn't get done correctly. So with a will, it's a much simpler document, but you are still going to potentially go through probate if that's the case. So even with getting a trust done at the last minute, the problem there is you're not going to have time to fund the trust either. You're not going to be able to get out there and get the assets transferred in. So more than likely, you're still going to end up going through probate, even if you get a trust ready. So quite often, I shy away from doing trusts when somebody does not have time like that. There are situations where maybe things get serious all of a sudden, and a great idea that I've seen is get a will done for the time being. And if the person gets better or gets in a better situation that they're more stable, you can turn right around and do a trust at that point too. So, I have a lot of clients that always kind of ask, okay, if I do a will, can I do a trust later? The answer is absolutely yes, is you can override that will by doing a trust after the fact, but trying to, fit the time and planning that it takes to get a trust put in place while somebody's on their deathbed, it's just kind of asking for a lot of trouble.
Exactly. Yeah, and I can get a rudimentary will we can get done pretty quick. In fact, I did one where we went out and it was pretty clear that there's this phenomenon in the hospice industry that many people may be familiar with, where people get that sudden surge in energy, and it was pretty clear to us that that's what had happened. Is this person had had their surge of energy? They called us. We got out there. We did a rudimentary will that got the that captured what they wanted. We got it signed, we got it executed, and then what we were going to do was go back with the more formal. It took us about 30 minutes to get that one done, and I was working up the formal will. The guy lays down, and thankfully we got that very rudimentary document done, um, because he laid down, went to sleep, and died. Oh, and we introduced it, and it held up just fine. But it was a moment where I realized, sometimes you got to make hay while the sun shines on these things, because folks who are actively in the dying process, there are moments where you may be able to get these things done, and then lots of time where you may not be able to accomplish their goal for them. So, so it's certainly something that we like to keep in mind, and I'm saying, if it's something that you're looking at right at the moment that you're looking at watching this video, you need to get a hold of an attorney quickly, because the moment may pass very quickly where it's available. So, is there, I think that's pretty much it. I mean, I don't have any, other than, if you're experiencing this, I don't have any sage words other than, the top priority very rarely should be the attorney,
Hmm.
especially in a dying process. We should be, in an ideal world, I don't get a call for a couple of weeks.
Hmm.
uh, I should not be the number one on your speed dial. I should not be, the person you're calling, 15 minutes after your parent dies or after your child dies. I should be down the line. In an ideal world, I would be down the line at least 2 weeks,
Hmm.
because there's just a lot of legwork that has to happen. The grieving process has to occur as well, and there's just a certain amount of distance um, between the time of death and the time the attorney can be really useful. Um, so it's certainly most of the time, and we hope that there's not something so hot and so frenzied that it has to be dealt with right there. But um, we would encourage everybody not to get in this situation in the first place. I think that's the kind of the ideal takeaway here is have your estate planning docs done early. Don't delay on that. Get them done before you get into a position where you need an emergent estate plan done. Um,
I might also add in just a couple other things here too, James, is one, beneficiary designations being updated. Again, they can be done while somebody's on their deathbed, but it makes a lot more sense to have it done ahead of time. Gifting and deeds are another important thing too, is making sure that you have other people's names on your property if that's what you do desire. because again, at the end of the day, it can avoid a lengthy court process and the expenses and everything that go along with it. One other thing I always say too is, especially, I don't know if we mentioned this too much, but a living will. Again, making sure you have your end of life decisions in place. You've communicated those to your family. It's again another very awkward spot to be in for kids to try to guess what mom or dad wanted when they can't answer them anymore. So again, I mean, we'll say this every time, but get the planning done ahead of time before stuff hits the fan like it does in these situations. But if you don't, again, make sure you're communicating as clearly as you possibly can to avoid surprises for people as well.
Absolutely. And, a lot of times people will um, call us up, and unfortunately, it is the nature of this type of planning that the attorney might not be available. That's the other piece that I just want to emphasize, because there can be times when we're in court out of in some rural county in Illinois or Iowa, and the attorney just might not be available, and people will call around, and it's hard to find an attorney sometimes if everybody's in court and everybody's tied up and everybody's got obligations. It can be difficult. So again, just make sure that planning happens ahead of time. I think that's pretty much it for this one. This one's going to be a short one here. And I would like to recognize, we do have a professional trustee in the audience. Melissa Zell is one of our trustees that we've worked with in the past. She's over at, I believe, First Community Trust. They're located she's located in our Rock Island office. Actually, she's located in a center building there, but great lady, great trustee. If people are considering getting a professional trustee or a professional to manage their estate. So certainly something to keep in mind. That's all we have for today. If anybody has any questions or concerns, certainly feel free to reach out to us. If you have any thoughts. My name is James Greenwood. I'm joined by Benjamin Young. We are the attorneys responsible for the content of this presentation. If you have questions, concerns, or any other comments, you can reach out to us at 855-528-6022. Again, 855-528-6022. We wish you the very best. Goodbye.